Thanks. How's everybody today? I know it's at the end of the day, though. We're doing good, though. But it's great to see everybody. And this year, we're going to be talking about managing the customer and the service provider relationship after that contract has been executed. I'm Cara Gunderson, Director of Payment Card Operations at Citgo Petroleum. With me is Greg Luna, Senior Legal Counsel at Citgo Petroleum Corporation, and Todd McClelland, who is Partner and Global Head of Cybersecurity and Data Privacy. So our goal this year is to take a balanced approach from both the merchant and the service provider perspective. If you attended our session last year, you might remember that we gave you some considerations for terms and conditions to include in your contracts. But this year, we want to provide some strategies and approaches for how parties can address PCI DSS, cybersecurity, and data privacy. I do have to provide the legal disclaimer is that we do have attorneys here and want to make sure that everybody understands that we are not providing legal advice. But if you do have questions, please seek an attorney who specializes in this area. With that, I'll kick it off to Greg.
Thank you, Cara. The first thing we wanted to talk about here is the types of contracts that you may have out there and the challenges that some of them may present. The first contract, legacy contract, old contract, it's been around for a while. Nobody's really taken a look at it in a long time, and it may have some outdated terms. The no leverage contract, this is where a merchant's looking for a service provider, really can't find anybody. They find one service provider, and it's got to be done, and it's going to be done on the service provider's terms. Conversely, there's a big customer. A service provider is going to want to bring in that big customer, and if it takes taking their contract, the merchant's contract, with their terms and conditions, that's what they'll do. And those are really just two subparts of the take it or leave it contract. You have no room to negotiate. The timing contract, this is a contract that you've got to get done at the end of the quarter, you got to get it done at the end of the year, and it just has to be signed, and you really don't have time to negotiate it. An inherited contract, that would be a contract that was from a predecessor company. You got it from a merger or an acquisition, and you didn't have any say in how those terms were negotiated. And lastly, we have someone else negotiated it. And really, the way to look at that is someone else didn't negotiate it. They just took what was there, and you may have some challenging terms there. So what do you do when you have a challenging contract? I'm going to turn it over to Todd and let him address what those signs are.
Well, that's where it comes from. But what is it? How do you know from a privacy, cyber, or other perspective you've got one of these great challenging contracts? First, and this is why we're largely here today, it's inadequate PCI DSS terms. And we're going to cover this at length during our brief talk here today. And we're going to focus on 12.8, 12.8.2, and other requirements. And then, of course, and this perhaps applies more if you're a service provider, is you've got terms that subject you to PCI DSS, either it does, period, or above and beyond, which you think you should have to be subject to PCI DSS. So if you're a service provider, that can make a challenging contract. And then, of course, there's breach notification. I think anyone who deals with vendor or merchant contracting, we're always seeing those terms that get inserted. You're going to notify me immediately. You're going to notify me after a confirmed breach. Whatever it may be, it's either aggressive or not aggressive enough. And then, of course, there's just risk. There's a breach. There's a non-compliance event. Who is shouldering and paying for that risk? There's also termination rights. You want the contract to be, you can get out of it any time, and you want the other side to be stuck in the contract until the fulfillment of the natural term of that thing. And then, of course, I think everyone knows, I think we've got like 13 new state privacy laws this year. And what we're seeing in our contracts, and this goes both ways, is that these privacy terms are increasingly becoming deficient.
Yep. So most of what we want to talk about today is requirement 12.8.2. And I think the biggest concern that merchants and service providers have is, what do I really need in that contract to comply with that requirement? And so that is really going to be our focus for today. I think everybody here is very familiar with this, so I'm not going to read it to you, but the cliff note here is that merchants must have an acknowledgement from the third-party service provider that they are responsible for the account data in which the service provider is in scope, right? But one of the important things here that we want to call out is the applicability note. And that really is that the requirement provides flexibility for what's in that agreement. So your agreement is going to vary. Your agreements will be different. It's also going to depend on the services that are provided, as well as the responsibilities that are assigned to each party. So really, the flexibility here is that there's nothing really prescribed in this requirement of exact language that you have to have, but you just do want that acknowledgement.
So we're going to walk now through 3 war stories. These are events that maybe 3 of us have experienced to some degree. We've altered the facts. We're not including names to protect the guilty here. But we're going to walk through these 3s. Each one of us is going to cover one. I'm going to cover the first one. Let's go ahead and dive into it. So the first scenario, I think many of you perhaps have encountered this. You've got that legacy vendor, merchant service provider relationship. It's been going on for years. And over time, you've added services. You know, we're going to pick up this. We're going to pick up that. But during the contracting process, or even informally, you never quite have kind of come to the conclusion that, hey, the service provider is in scope, or should have been at the time of contracting. And then at some point, you go through your assessment, you're doing your scoping exercise, and holy cow, this merchant actually, or the service provider rather, should be in scope. So the merchant approaches the service provider and says, hey, we got to talk. So in this particular scenario, we had one of these relationships come up, or one of these situations come up, and we were with the merchant, and we had a service provider, and we sat down and we talked about, hey, do we need to do something contractually to address these new requirements under the new standard? And in this particular situation, we each engaged PCI experts. I was brought in as legal counsel, and we found 4 things in the contract that we really paid most attention to. First, we looked at this clause in the contract that said the service provider was going to comply with quote-unquote applicable industry standards. PCI-DSS is definitely an applicable industry standard when it comes to account data. Then we looked at these other requirements. There was this lengthy exhibit that went through all these controls the service provider was going to comply with. So in the process of mapping out the allocation of compliance responsibility, we said, hey, that probably covers us from that respect. Then we looked at the audit rights, which were extensively broad, and they included, among other things, the fact that the service provider would cooperate with any assessors or auditors. That was good. But number 4 was perhaps the best one from a 12.8.2 requirement. There was a confidentiality provision. The confidentiality extended to all data that was going to be exchanged or processed by the service provider for the merchant, and that would probably cover account data. And then there's further this obligation or an acknowledgement by the service provider. They were responsible for protecting confidential information, once again, which included account data. So from that alone, we thought those 4 things probably got us there from a PCI DSS perspective. So what did we learn about this? I think there's a knee-jerk reaction when there's a new standard. Hey, new standard, got to have an amendment to the contract, right? We delved into this contract, looked at what was already there, and found that we probably protected our needs. We also saw that with 12.8.2, and Cara just walked us through this, that there's some flexibility. There is no precise or particular language you have to agree to. That being said, we do need to have that 12.8.2 acknowledgement, what this contract did. So I think what we learned from this was we need to stop, pause, engage experts, look at the contract and see if what it has is going to be sufficient. And in this case, fortunately, it was, because people hate reopening contracts.
So in this second scenario, we're going to again talk about a targeted amendment of an existing contract. And for purposes of this scenario, we're talking about an old legacy contract for security services. Now, in this scenario, the security services affected the merchant's cardholder data environment. During a scoping exercise, the merchant determined that it believed that those services were in scope. So it informed the service provider, we believe you guys are in scope. Service provider comes back and says, no, I don't think so. We're not in scope. The parties go back and forth and really nothing gets done. So they come to a resolution. Let's take it out of the parties' hands. Let's each of us hire a PCI expert and make a determination. So for purposes of this scenario, the service provider, PCI expert, and comes back and says, we agree with the merchant. These services probably are in scope and they need to be acknowledged. And So the parties agreed to this targeted amendment, and they're able to reach a resolution that is specific only to that issue, because the parties really don't want to open up the contract to any of the terms and conditions, some of which that Todd talked about. You don't want to renegotiate audit rights, certainly payment, and all of the other things that could be under a contract. So the parties here are able to get a targeted amendment and come to a resolution. But a little twist, the merchant comes back and says, we want also a responsibility matrix to be part of that contract amendment. The service provider pushes back and says, no, I don't think so. We don't want that to be in the contract amendment. We don't believe that's required by PCI DSS. So we're at a loggerhead again. So what the parties do in this situation is they come to an agreement and try to make sure that they can get the amendment done, and they're able to resolve this by getting the responsibility matrix completed outside of the contract. So each of the parties gets somewhat what they wanted, and really the service provider in this situation gets the benefit of realizing they probably have other customers that are in scope, and they could use this targeted contract amendment for them, as well as a responsibility matrix as well. So what we have here then is some good faith, transparent negotiations between the parties. It didn't get ugly. Nobody threatened to go to court. Nobody threatened to try to get out of the contract or determine that the contract was terminated. This last bullet point, we really didn't talk about it too much in this scenario, but there is a purpose, a good resolution to have a QSA issued attestation of compliance or report of compliance. In the event there is a data breach, both of the parties can look at that and use that as some fairly demonstrable evidence in case there's a data breach that results in either litigation or a government investigation, and you have some evidence that there was quite a bit of prevention of data fraud.
Great. Those are two great contract scenarios. So for our third and final scenario, I'm going to use a lot of what Greg had outlined, except for the fact that the parties could not agree on PCI DSS scope, and therefore they exited the relationship. So as the merchant was conducting their PCI DSS required scoping, they realized that one of their existing service providers was in scope because of the technical services that they provided could affect the security of the CDE. And the service provider had never been in the merchant's scope previously, so the merchant had not discussed that. So when they approached the service provider said, well, we're not in scope. We don't have access to cardholder data. But again, through the scoping, the merchant said, we believe that you are. And so the parties could not agree, and especially the service provider objected to the monitoring, the security, and information sharing measures that would have enabled that merchant to be PCI DSS compliant. So the approach that they took here is that the parties agreed each to seek their own PCI expert or go to their QSAs and talk with their QSAs. While both PCI experts had great arguments after much discussion, each expert agreed with their own side. So next, the merchant turned to their contract and engaged their legal to review their rights and remedies. And unfortunately, the contract only allowed termination for material breach. The service provider indicated that they were not in breach, but in the end, they ended up reaching an amicable approach and allowing the termination. Now, termination is always your last resort here. And so, but we also know that this is a pretty small arena. And so everybody pretty much knows everybody here. So it's a really good idea to be cooperative and a good partner. If your QSA experts don't always agree, as a merchant, your next step, go to your acquirer, seek their opinion. As it's always a good idea to bring in your legal very early in the game because you want to make sure that you have a defensible position. because in this case, the service provider threatened litigation for termination. Now, the termination is very time-consuming, costly, and possibly could affect their operations for the merchants. And for the service providers, it's also costly. You didn't get the revenue that you expected to realize. So we really encourage to try and be good partners in this arena. So the last section here is we want to talk about other risk mitigating measures, because I think that while we talked about 12.8.2 a lot, there are other requirements in 12.8 that allow the merchant to work with the service provider outside of the contract to meet some of those PCI requirements. One of the things that I can't stress enough, and I talk to Todd and I talk to Greg almost daily. I don't know if that's good or bad, but we do work together very, very often, and so I'm very, very lucky that I have access to these folks. But we've gotten really, really, really creative. Todd talked about the transparency, and so working together and to help the merchant and the service provider both achieve PCI DSS requirements.
So continuing with this theme of finding things outside the contract, we've got this contract signed. What are we going to do to further mitigate any risk? We may not have that great contract for the reasons that Greg and I walked through earlier. So what else can we do? One of the things we can do is minimize exposure to data and systems. We're seeing a lot of regulators. We've seen FTC actions, state AG actions. We're seeing lawsuits every day. And all of them are going towards the same thing, data sprawl. They're going after data minimization. So what can we do? We can minimize data. We can minimize access to cardholder data, account data, I guess is the term I should be saying. We can minimize the access to CDE and other sensitive systems. So reducing access, reducing volumes, getting rid of data when we no longer need it. That's the single greatest way to reduce cybersecurity breach exposure and minimize our compliance obligations. Also, if we have an incident, or if we're trying to protect against one, we want to start thinking about this proactively and put ourselves in a defensible legal position. So one of the things we can do if we're a merchant or if we're a service provider and we have vendors is start to look at what kind of documentation they already provide. Do they have an ISO certificate we can download from their trust center or whatever site that they have? Do we have any AOC that they may make publicly available or anything else? By getting that stuff, storing a copy of it for that rainy day, it helps once again bolster our position should that third party have an incident. Hey, we did our thing. We looked into their security posture. We can also look into things that do like their questionnaires. We can send out questionnaires from time to time and see what are they doing. Ask them, how are you securing our data? What are you doing with our data? We can look at, get news subscriptions. We can sign up to Bing and Yahoo and all these other sites where if our vendor or our service provider has an incident, we get a notification. And I think most people, if I ask the question, has anyone heard of anyone getting affected by a MOVEit incident? We know these are affecting the supply chain. So we've got to be diligent. And Greg's going to talk about this a little bit more in a minute. But we can start to get really active in looking at, if our vendor or service provider has an incident, ask them some questions. What happened? And then last, there's a lot of third-party services out there that their business is kind of doing scorecards and security overviews of companies that are out there. We've got here listed, BitSight Security Scorecard. There's others. But signing up for these services and having someone else doing this for us makes our life easier. They're doing a good job of it, and it might just be worth the investment.
Another mitigating effort is the concept of every dog gets one free bite. What does that mean? So we learned pretty early in law school, pretty much the first semester, that every dog gets one free first bite, meaning you have a dog, it bites somebody, you're going to have lesser liability, lesser damages if you are unaware that your dog was prone to bite people. However, if your dog has a second bite, you're on notice that your dog has a propensity to bite people. So once it happens the second time, you're on notice and you're going to be exposed to damages and more liability. So why am I telling you that? If you're thinking, I have a dog, it could bite somebody for free, that's not the point. The point is, if you're a merchant and you have a security breach, you're thereafter on notice. You have to work with your service provider investigate, determine what happened, and take corrective action so that it doesn't happen again. After the first incident, the first security breach, do you have to get rid of your service provider? Much like you don't have to send Rusty up to the country to live out his days, you don't have to get rid of your service provider, but it is incumbent on the merchant to take the corrective action and make sure that it doesn't happen again.
All right, I get to bring this home with the absolutely most exciting topic, cyber liability insurance. So this is an increasing thing that a lot of companies are getting these days. And when we have that contract where maybe we're shouldering more of the risk, offsetting the financial risk there through cyber liability insurance may be something to consider. But there's a number of things to think through. What is going to be the deductible? Will it cover that third party if they have some kind of an incident? What are the exclusions? And a number of questions. My practical point here is if you're looking at cyber liability insurance, bring in a professional who knows something about this. This is from a legal perspective, it's a very dynamic issue right now. A lot of issues about what's covered, what's not. Our nation state attacks covered. This stuff it's a very quickly evolving area. Get good counsel to represent you. Now, going back to something Cara said a few minutes ago about being creative, what is often common in certain merchant and service provider contracts is one party will ask the other to carry certain kind of coverage. But that can affect deal value. And if these are more bespoke services, well, maybe insurance is not factored into the cost of performance. And so this comes back to that creativity principle. You really need to think about how can we go out and get this, who's going to get it, and you've got to be very creative about how you're going to go about trying to offset risk using insurance.
Thank you. So we've reached the end of our time, and I want to thank you for coming today. We put a lot of words on the slides, and our recap is no different, but we wanted to give you a great presentation that you could download, take back with you, talk with your own in-house counsel. Maybe you're lucky like me, where my in-house counsel engages experts like Todd. And thank you very much for coming today. Appreciate it.
Thank you.